Good afternoon and good morning to those joining us out west. I'm Karen Langdon with the National Emergency Management Association, and I'd like to welcome you to the NEMA Empowerment e-learning series. We're very excited to showcase the expertise of NEMA members and partners in this series, and we're happy today to be joined by CBCA, Nichols Liu, Tetra Tech, and FEMA for the topic of contesting FEMA public assistance grant decisions at the Civilian Board of Contract Appeals. And now I'll turn it over to Sam Van Kopp, Associate at Nichols Liu. Take it away, Sam.
Thank you, Karen. So Sam Van Kopp, I'm an associate at the firm of Nichols Liu. I was also formerly a clerk at the Civilian Board of Contract Appeals. And to give you just the lay of the land here for about 2 minutes, I'm sure everyone on the call is familiar with the Public Assistance Grant Program and with the appeals process internal to FEMA anytime that an applicant wants to contest an element of their eligibility. What is different in this case is that in 2018, Congress authorized a new capacity to dispute decisions made by FEMA before the Civilian Board of Contract Appeals. And there are a couple of circumstances at play here. You have to have already appealed within FEMA, and your appeal must either have been decided at the first level, but not the second, or you must have been waiting for a decision for at least 180 days. But in that circumstance, you would be able to go before this third party, or the CBCA, instead of staying internally inside FEMA. And if you want more details on that, there's a briefing paper from Thomson Reuters that's on our website, and we're going to talk about it during the second session, where we have a distinguished guest. We have Brock Pearson from FEMA, who actually runs the arbitration program from FEMA. He'll be talking with us. And we also have Allison McCleary from Tetra Tech, who's a practitioner in this field and in charge of their disaster program. But first, we have a very incredible treat. We have 4 judges from the Civilian Board of Contract Appeals, the body that actually conducts these arbitrations. And they're going to talk a little bit about the program. Each judge will introduce themselves in a second, but first let me point this out to folks who aren't familiar with the CBCA. There are only 13 judges on the entire board, and of course the number of arbitrations they've heard has exploded over the years. So for them to spend this time out of their busy day to speak to us is an incredible gift, and so we're very thankful for it. And with that, Judge Lester, as Vice Chair, would you like to begin? I'd ask also for the judges now to turn on your cameras.
I don't know, Sam. Would I like to begin? Does anyone want me to begin?
Yeah, okay.
So let me just a quick correction. We actually have 12 judges on our board. We unfortunately, one of our judges passed away. Judge Drummond passed away in late June. So we are very sad for him and about that, and have great sympathy for his family. But we also a new judge just started a couple weeks ago, Jonathan Kong,
right now, okay,
who came from the from GAO. And so, but I think the way we've sort of tasked this is I'm going to start and just give a brief introduction, and then of our arbitration program at the board. But before that, let me just introduce myself. I am Harold Lester, although everyone calls me Harv. I am one of the 2 vice chairs here at the board. Our chair is Erica Beardsley, and I've been here as an administrative judge since, as a board judge since 2014. I spent a lot of time doing government contracts litigation, both in private firms and at the Department of Justice before I came to the board. Traditionally, the CBCA was created by statute to have an expertise in contract disputes resolution and contract disputes litigation. But back in, I can't remember the year, we did take on arbitration authority through a memorandum of understanding with FEMA, where we helped provided arbitration, a binding arbitration for disaster relief that FEMA had denied, but it was limited to the damages caused by hurricanes Katrina, Rita, or Gustav. As those cases were really starting to wind down, in October 2018, Congress actually amended the Stafford Act to make our arbitration authority statutory in nature. And beyond that, it expanded it to basically all presidentially declared disasters from a certain point in 2016 onward. So since that declaration was made by Congress, or that authorization was provided by Congress, we have been working to figure out how best to address the arbitration matters that parties have brought to us, encompassing all kinds of disasters: wildfires, flooding, earthquakes, as well as hurricanes. So under the statute, which is located at 42 USC section 5189A, an applicant for assistance can, I'm just going to quote it, request arbitration to dispute the eligibility for assistance or repayment of assistance provided for a dispute of more than $500,000 for any disaster that occurred after January 1st, 2016. For applicants in rural areas, which the statute defines as an area with a population of less than 200,000 outside an urbanized area, the assistance amount eligible for arbitration is $100,000 or more. And we have seen, the dollar figures run the gamut from matters that are just above that $100,000 limit for rural areas up into the tens of millions of dollars. In a single arbitration. So the dollar figures that we're dealing with really go over a broad spectrum. When we got this authority in 2018, it took us a little bit by surprise. We weren't a part of the development process for the legislation. And the first time we heard about it was after the statute had been amended. So we had to jump on it right away and had to work quickly to digest what it was the scope of our authority was. And importantly, particularly with Judge Chadwick and others' help here at the board, developed and put into place a set of procedural rules for both parties and the board to follow in the arbitrations that are before us. And those rules are published in the Code of Federal Regulations at 48 CFR 6106.601 and are also available on the board's website at www.cbca.gov. Generally, for those of you who don't know, if you've appeared before us, you probably do, but we always appear in these matters as a panel of 3 judges. So that panel is assigned when the case is docketed. You're told who the panel is, and typically that 3-judge panel is going to sit in a hearing where the evidence is presented in the case. And that 3-judge panel, and then a decision will be issued at the end of the arbitration. Our rules do allow some exceptions to that, exceptions to a matter being heard by the whole 3-judge panel. For example, where the parties, for whatever reason, would like the hearing to be held outside of our offices in Washington, D.C. and want a judge to travel, our rules allow a single judge to preside over the hearing. And parties may also elect to have just a paper hearing on the written record and forego live witness testimony. And as some of you may be familiar with, during the pandemic, we really did a lot of what we're doing right now, which is being on Zoom. Like all of you, we were sort of not sure how that would work, but it seemed to be pretty successful. It precludes people from having to travel. We can get close up and personal as you are on your camera, and that is something that we are continuing to permit, to have Zoom hearings, virtual hearings. We're working to provide for some hybrid hearings. Some people want to be on Zoom, some people want to be in person, and we're also having in-person hearings again. So we're trying to maintain some of the flexibility that we were sort of forced to create when the pandemic began, but we're trying to maintain the benefits of that as time goes on. We're happy to be here today. Thank you to Sam and to Nichols Liu and all the other folks who put this program together. And we're happy to talk about our impressions based on our experiences so far with the FEMA arbitration matters we've seen. One thing I want to clarify before we get started, though, is we got a lot of questions from folks. Sam forwarded questions to us that people had put in. Some of those questions sort of geared towards requests for legal advice and predictions on how FEMA panels might rule in certain circumstances. And I just want to point out that that's one thing we're not going to do today. We're not going to, each panel, each 3-judge panel makes its decision in a case independently of what prior panels have held. Although our decisions in arbitrations are published on our website and end up on Westlaw and Lexis and in the BCA Reporter, one panel is not bound by a prior panel's decision in an arbitration, which is unlike our CDA jurisdiction, where we do view a panel decision as binding on future board panels. But just because one panel thinks one thing, a later panel might disagree. And because of that and for other reasons, we're going to try to steer clear of what might be viewed as providing legal advice to parties or to predict how a particular panel might decide a case in light of a specific set of circumstances. But that being said, we're happy to share some of our thoughts today in response to some of the questions that you all submitted. Some of them were sort of tough questions to think about. But before we jump to the first one, which is going to be Judge Sheridan, so get ready, Judge Sheridan. I just wanted to give you just a quick little note about how our arbitration authority has been perceived, at least based on the numbers that we're seeing. That first fiscal year where we were deciding, where we had our new authority was fiscal year 2019. And in that year, we docketed 12 new FEMA arbitrations. In 2021, we docketed 27. And last fiscal year, we docketed 52 new FEMA arbitrations. So the numbers seem to be going way up. This year, we're pretty close to being on target for keeping pace with last year. So maybe we're slowing down just a tad, or maybe we found a temporary plateau. But these are becoming a big part of the board's practice. And there's something, because they move so quickly and are supposed to move so quickly, there are things that we have to jump to when they come in and give our full attention to. So we are learning along as you all are about these processes. And so thanks for having us. So Judge Sheridan, you get to introduce yourself now, and you get to address the first question.
Lucky me. I am Judge Patricia Sheridan. I started off in private practice doing, after law school, doing malpractice and a general practice, which I always say I did everything and nothing well. It was anything that walked in the door. And I really didn't like that. So what I decided was to look for something where I could specialize. And I found that at the Department of Veterans Affairs, they hired me as a trial attorney and a counselor for their contract disputes practice. And I did that for several years. And along the way, I caught the eye of the chair of the VA Board of Contract Appeals, who had noticed my work, and I had appeared before several times. And he asked me to join the VA Board of Contract Appeals as a hearing examiner and his counsel, which I did. And again, what I would do there is I would write decisions for judges, hold hearings for judges, and then the judges would sign their name. They would edit the decisions and sign their name onto the decisions. So I did that until 2000, when I was made a judge at the VA Board of Contract Appeals. Also during that time, what is known in the federal government as the Administrative Dispute Resolution Act of 1990 encouraged federal agencies to start using ADR to help resolve disputes. And my boss became the VA's dispute resolution specialist. And he told me to make him look good, essentially. And so what I did that by starting to institute programs at the VA where different types of ADR could be used. Now, mediation and arbitration are two forms of ADR. And there are other forms of ADR, but basically I did that alongside of my job as the hearing examiner and counselor. So I did that, and in the process, I also started doing arbitrations for the Better Business Bureau. I did mediations for the DC Civil Rights Department. You know, just trying to get experience in different types of alternate dispute resolution. Let's see. When the Board of Contract Appeals merged with the other boards, I put away all the various types of ADR I did and focused on contract disputes. And then we got the arbitration for the FEMA stuff. All of our judges have received training in how to best use ADR. I have also taught mediation skills at various places to hundreds of federal employees. So, and Judge Lester has explained to you the different types of jurisdiction we have. And so basically, I've been working in this area for about 40 years. The topic that I am going to discuss is a question we received, which is, how long does the arbitration process take to come to a resolution/decision? Well, we have various deadlines that apply to these cases, and we try very hard to meet the schedule that's set by the regulations, the board's regulations. Usually we do that, but sometimes various obstacles get in our way. When a FEMA case is docketed, it is assigned to one judge as the lead and two other judges as panel members. This is done totally randomly. And ordinarily within 14 days, one or more of the panel will conduct a telephonic scheduling conference with all the parties. So that's one day, one deadline that you have to be aware of. After that conference, the lead judge will issue a written summary of the conference and schedule and put in due dates for various things. I deviate a little from this practice by issuing a scheduling memorandum setting a hearing date immediately upon it being assigned to me. The reason I do this is because arbitration becomes harder and harder to schedule as it gets later and later. You have to remember that we have to find 3 judges that can be there the same day or days. And then you've got usually at least 3 parties and their witnesses who also need to be there. So what I do is immediately upon docketing, I pick a date I check with my judges on the panel and I pick a date for the arbitration and say, if an arbitration is needed, it's going to be done on such and such a day. So I do that because I'd rather get the hearing date set than have to play with the parties, and that can take a lot of time and patience that I do not have, is trying to find a date later on where everybody can make it and still meet the other deadlines that are in play. And as far as evidence goes, evidence can be filed up until the record is closed, but the earlier it gets submitted, the more attention it will likely get from the panel. Late filed evidence, like a day before the arbitration, may not even be read by the panel member by the arbitration. So get your evidence in as early as you can. This includes expert opinions. My orders will usually state a cutoff date for filing evidence that a party wants the panel to consider. And but not all judges do that. the fun thing about practicing before us is that each judge has their own little style and way they like to see things done. So we keep you jumping, and we're aware of that. So I think I have a practice where I'm pushing it ahead faster, you know, somebody else might take it slower. So that's just something to keep in mind. FEMA gets 30 days from when the application is filed to respond to the application. All right. That's by regulation. The judges will usually set a date for the parties to let them know what type of proceeding they want. For instance, do you want to have an arbitration hearing where you call witnesses? More and more, we've been doing things where we ask the parties to submit direct examination in writing, and we just do cross in a hearing. And that's done to shorten the arbitration and the amount of time that we have to spend in a hearing. So you may be asked to do that if you ask for a hearing. Sometimes, you know, it's live or Zoom. Is it a one judge thing, or is it 3 judges? Is it a decision on the written record? We call it a paper decision, with or without briefs. You all have these options, okay, which we discuss during while the case is being developed. So those are all allowed under the rules. However, the hearing must begin within 60 days after the initial conference, unless the chair approves another date. So that's another date that we are very aware of. So once we have the initial conference, the time gets ticking, and we have to have a hearing within 60 days. The panel will advise the party when the arbitration is closed. And what that means is basically they're not going to accept any more evidence or any more testimony. And that usually occurs at the end of a hearing, or after the parties have submitted briefs, if it's going to be on the written record. Sometimes during a hearing, the parties will decide that they need something specific, and the panel will think that it's going to be helpful, and they'll keep the hearing open until they can get in that piece of evidence. That's very rare, however. We don't look favorably upon that. It's basically, you know, we want an end to this proceeding. Okay. So if you're going to have a hearing, be prepared to spill it all by then. The panel will resolve a dispute within 60 days after closing the record. So again, that's probably 60 days within the hearing, the day of the hearing. Decisions may be issued in writing, orally, or orally with transcription. We won't reconsider the rule says we shouldn't reconsider an arbitration decision, or a decision is not precedential, meaning we don't rely on old decisions and say, oh, gee, you know, this panel did this, we're going to do the same thing. And basically, that's it, except for we can correct clerical errors or arithmetical errors within 30 days after issuance of a decision. So those are all the deadlines that we care about.
Great. I think the takeaway is these are designed to move quickly. These are not supposed to last for years, and we work hard to try to make sure that happens. So Judge O'Rourke, you're next up.
I thought Judge Chadwick was next.
Oh, Judge Chadwick is next up. I was just trying to keep you on your toes.
Either way. Okay. I'm Judge Kyle Chadwick. I started at the board in 2016 on the exact same day as Judge O'Rourke, as well as 2 of our other colleagues. And prior to that, after law school, clerked on a court of appeals, worked for a couple law firms, and then importantly, spent time at the Department of Justice for 9+ years, where I worked with Judge Lester, and also been at the Federal Trade Commission, spent time in the U.S. Army's contract litigation shop as well, among other things. So one thing that I bring is that I have practiced in a variety of tribunals, from the administrative and informal all the way up to courts of appeals. So I've seen a lot of litigation and ADR as well. So I'm going to address a couple of questions. There's two that were similar that I think we can merge together. And one of those is, in your experience, has the arbitration process become more adversarial as FEMA and applicants have lawyered up? I'll just point out FEMA always had lawyers, but we get what you're saying. And the other one is similar, but should you be represented by an attorney, or is knowledge of the program enough to navigate the process? Good questions. Again, as Judge Lester said, we're not here to give you advice and tell you what to do, but I think it's worth asking and think about it in terms of, what can a lawyer do for you, and what kind of arguments are you making? What do you need to do? So a lawyer is going to be trained basically at keeping an orderly record, organizing a relatively voluminous set of either documents or maybe a list of arguments, explaining how they go together, and presenting to the judges, in a way that does not require, because frankly, we won't put up with it, walking through every single document individually, right? A lawyer has a way of gathering a case together and summarizing it. Do you need that? Probably depends on the volume of documents we're talking about, and the record that you're going to try to show us. Another thing a lawyer is versed at is organizing arguments based on legal sources, such as policy documents. In other words, looking at the words and making arguments about what do those words actually mean. And so you might want to think about, are you in a disagreement with FEMA? Is the nature of your disagreement something about you disagree about what some words should reasonably be read to mean? A non-lawyer can obviously argue that too, but that's something that lawyers get used to doing, and you might want to think about whether that's the nature of the argument that you want to make. And another thing, of course, we've talked about, Judge Sheridan did a nice rundown of the relatively fast track we try to stay on that might end in a live hearing. And probably what many of you are thinking is that a lawyer is trained at appearing at a hearing like that, right? And asking questions of witnesses, making arguments directly to the judges, responding to their questions. We actually, and our rules make clear that you don't need to be represented by a lawyer. Well, FEMA does, but you don't need to be the applicant community don't need to be represented by a lawyer. And we have certainly seen agency heads, and certainly you can imagine the type of person who's sometimes put in charge of an important state agency is someone who's perfectly capable of speaking to us and has dealt with lawyers and maybe with judges before as well. And we can get what we need from those people very often. But the nuts and bolts of asking questions of a witness, how do you do that? Do you object? When do you get to talk? It's fine. We're capable and willing to talk to non-lawyers and kind of guide them through what a hearing might look like if we need to do that. But of course, it's going to be comfortable and more smooth if you have maybe a lawyer doing that for you. So we don't necessarily encourage anything about that. And as Judge Sheridan indicated, you can go just on paper, and we'll call that a paper hearing. So you don't, this isn't a case that you shouldn't think of it as necessarily sort of a case that needs to be tried if you don't think you have that kind of argument that you need to make to us. It all depends on what you want to present to us. I think a flip side of that, just take another couple of minutes. Flip side of that is you might think of, well, what would a lawyer possibly do that I might not need? And that gets to this question of whether the process has become adversarial. I don't know if we want to comment on trends or anything, but I think I speak for all of us, and you got a flavor of this from Judge Lester and Judge Sheridan, that what we really want to do is focus on what should we do here? What is the right answer? We want to get our minds around it, and someone has to draft up something, and we have to talk about it, and we want to get it done and get it out in a speedy fashion, as we should in arbitration. So what is not helpful to us is something that sometimes lawyers are used to doing, which is sort of jabbing at each other's case, making snide remarks, making objections you don't need to make. Those things slow us down. We really aren't interested in the performance aspects of putting on these matters to us. We prefer that you leave that elsewhere. And so you don't need that. And more broadly, I would say you don't, you, the applicant, don't prevail just by showing that FEMA was wrong. This isn't, we're not a jury. This isn't like a tort case where you're showing negligence and incompetence on the other side. We're not interested in hearing about that. We want to know who's right. What is right about your position? And obviously you're in a disagreement with FEMA, and that will involve you explaining what's wrong with them. But there's in some fields of law, as we all know, and if nothing else we know from television, there's a desire to sort of cross-examine the other side and get them to break down on the stand and admit that actually you're right, and things like that. And we don't really have a need for that, and sometimes don't have a lot of patience for that kind of extensive engagement with the other side, and like undercutting their view in that sort of lawyerly way. We prefer to just focus on what's right about your view, where do you disagree, what words are at issue, what facts are at issue, and what's the evidence that we need to hear. So non-lawyers can do that. Lawyers are more used to doing that, and you might want to think about not sort of over lawyering in ways that the panel might not appreciate. So that's what I'd say about that. I don't know if my colleagues have further thoughts on that.
I think that lawyers can also give you a fresh look if they are, I mean, you can hire a lawyer just to argue your case, but also you can hire a lawyer to look at what FEMA is saying and to see whether there are any better arguments that could be made than you're making, or you know, how, or whether you should spend the money to pursue it. And I think that a lot of applicants are so entrenched in needing the money that they don't look at things clearly necessarily. And I would hope that a lawyer would help them do that, rather than just take their money and be their mouthpiece.
But I mean, I do think we should make clear that you, as Judge Chadwick said, you don't have to have a lawyer to come here. These hearings are not like courtroom proceedings where people are objecting to hearsay, or people do, but there's really no basis for it, because these are supposed to be informal. So, you know, if you have an uncomplicated, you know, if you have a super complicated case, you've got to prove like 87 different elements, and you've got to make sure you're tracking all the evidence for each one, that might, you know, you might want to have help for that, perhaps. If it's something really simple, maybe you don't need help. So, you know, there's just no one size fits all response to the question, but just know you don't have to have a lawyer to appear before us, and we certainly have people who have well represented themselves without a lawyer involved. All right, Judge O'Rourke, because our time is ticking, it's your turn.
Okay. All right. I'm Kathleen O'Rourke, and I've been, as Judge Chadwick said, I've been a judge at the board since 2016 when he joined, along with two other colleagues. Before that, I would say the bulk of my legal career was in the United States Air Force, where I served for 20 years on active duty. Most of that time, I was a contract litigator for the Air Force, both on their contract litigation team, doing bid protests and administration disputes, as well as deploying to Afghanistan and working cases under Joint Contracting Command, where I work for the Army, doing a lot of huge construction cases. And then I was the staff judge advocate for the Air Force Civil Engineer Center for 3 years. So again, that was a lot of big construction contracts and environmental cleanup contracts. And we did a lot of mediation, binding arbitration during that time as well. I was after I retired from active duty, I joined the Department of Commerce, where I worked on some of their interesting projects, the First Responder Network Authority, which involved a lot of procurement actions. And then I joined the board. So I have been doing these FEMA cases, and as Judge Lester had mentioned, they have increased substantially. The questions I'm going to answer today involve, I think the question was methods of achieving success, and the other one was, please describe some trends you're seeing in arbitrations, like where applicants are having success and where they're not. So the first thing I wanted to ask, is I might have missed this at the beginning during the intro, and Ms. Langdon or Mr. Van Kopp, if you could answer this. Is the audience primarily consisting of emergency managers, or are they all attorneys? I mean, or is it a mix?
Definitely a mix. Definitely a mix.
Okay. All right. So, I'm going to stay away from like a lot of legalese, because we've got emergency managers in the audience, and I want to make sure that, what we're saying makes sense just to anybody involved in this process at any level. So the first thing that we acknowledge is the context that these things are happening. When you're performing your mission as an emergency manager, where you're trying to walk into a city or a state or somewhere, it could be an island in the middle of the ocean, and you're focused on cleaning up and restoring power and those types of things. The last thing you're probably thinking about is litigation and making sure you're collecting evidence as you're trying to make sure there are enough electrical companies dispatched to pull trees out of electrical wires. So I think FEMA understands that. From our practice, we can see that there is an understanding of the type of environment that you're working in. So by the time it comes to arbitration, we understand this can be long after the disaster. And the evidence, if you're waiting till the end to prepare for the case, it's hard because a lot of the evidence maybe is gone. So in terms of methods of success, I guess what I would say is, first of all, know the regulations. You're probably familiar with the Papa G that the FEMA has, and then we've mentioned our rules. Judge Sheridan mentioned our rules, Judge Lester and Judge Chadwick. We have rules, so make sure you're very familiar with the rules, and don't wait till the disaster hits to start reading the Papa G. I think if you're pretty well versed in our rules and the Papa G, then you're going to understand going in what you're going to be looking for, what kinds of things you're going to need to document and record, so that in case you have to preserve it for litigation later. The other thing I would say is, just because you might be familiar with one from a disaster years ago, it may not be the one that applies today. Know that the policies are updated, things change, and so make sure you stay on top of updates. And also just understand the process from start to finish too, because some of what we see involves the very, very end of the process, involving reconciliation, where FEMA and the applicant are going through, they were awarded public assistance, and then they're supposed to use it in a particular way. And maybe at the end during reconciliation, a dispute arises and FEMA's kind of clawing back some of the money. So know that it's a long process. So I encourage everybody to know the rules and regulations, but also from start to finish, because it's not over just after you get the award. Another thing is, just because it might have worked in your last disaster, okay, we hear this a lot. We submitted this during the last tropical storm or during the last hurricane, and it was awarded to us, but for some reason that we're using the same method and that's not working. Now, I'm not going to speak for FEMA. We have FEMA representatives that are going to be presenting things, but we hear that a lot and we understand, but just know that if you are following the rules and the guidance and you have all of your evidence and it's tied to certain things to support the cost that you're claiming, it may have worked the last time, but it may not work this time. So I guess the successful folks are the ones who are thorough, and understanding as things evolve and as disasters increase, and the costs increase, that the adequacy of the documentation is important. Let's see, what else do I have on here?
One of the things that I would say is conclusory statements, which is basically, I should win this, okay, without tying that statement to underlying evidence, like why you should win this, with particularity, is not something that we're going to be listening to. All right. You need to all the money we spent was an emergency measure, was for emergency measures. That doesn't convince us that is, and that's not helpful to us. What you need to do is you need to drill down and say, okay, here's what this guy did, and this is why it's tied to emergency measures. So too often we just see conclusory statements, and we're dealing with a conclusory statement from FEMA and a conclusory statement from the applicant. And it's sort of like, well, what are we supposed to do with this?
Yes, and I think the point there is, like, more evidence isn't necessarily better evidence. It's got to be tailored and it's got to be sufficient, but it should be effective. So just because you're dumping lots of information into the process doesn't mean it's necessarily going to be responsive to the issues. One of my colleagues had talked about not dumping a lot of information on the panel, the arbitration panel, right before the arbitration hearing. So that's just something to keep in mind. Some of the other judges mentioned, the earlier, the better that you get that information forward.
We typically do read all the briefs and all the evidence that's put before us, but if we can't understand it, because it's not put into a context that we can understand, it's not of much value.
Also consider that the hearing should supplement, not be redundant with the documents in the record. It should add value, because again, you're taking time, it's expensive, I'm sure, hiring lawyers and doing the arbitration. So make sure it's adding value. I think we've, as the numbers of cases have increased, we've become very disciplined in terms of how much time we're going to allot to things. When I first got here, it was 2 or 3 days, maybe they would set aside. There'd be all kinds of parade of witnesses in person. Now it's virtual. If you want a hearing that's going to last more than a half a day or a day, you have to persuade me along with my panel, because I'm not going to listen to testimony about evidence that's in the record. So it's got to be something that's going to add value. Then the last question about the trends, the only thing I would say is, as Judge Lester mentioned, the disasters have increased. We've got more numbers. We have an expanded jurisdiction. So the amount of cases that we are currently handling, I think, is more than we've ever handled. So just make sure whatever you're bringing before us, that your costs that you're saying that you want reimbursed, you've got to make sure that the evidence that you're presenting matches those costs. So if you're saying you want $1 million, but the evidence only supports about 300,000, there's going to be a problem. I know that might seem obvious or intuitive, but sometimes folks are so busy getting all the paperwork together and trying to get organized, nobody's actually crunching the numbers. So just make sure you double check those. Thanks.
Sam, can I check with you? What is our time? I'm not quite sure how much, when you want us to stop. We have more questions to answer, but I don't want to step on other people's time.
Judge, I think if we terminate it at 3 o'clock with this first session, that'll save 30 minutes for our second session with Brock Pearson and Allison McCleary.
Okay, great. Well, so I am supposed to address another question, which was, what are the most common mistakes that parties to FEMA well, I'm going to rephrase it. What are the most common mistakes that FEMA applicants make during arbitrations? I think Judge Sheridan and Judge O'Rourke just talked about some of them. So I'm going to paraphrase that and keep them quicker, or keep them quick. To me, one is they just talked about was really failing to piece together all the elements that you need to prevail. I think sometimes it's good before you, at least before you get into the hearing, but also before you even file your arbitration request, is to sit back, look at the Papa G. What are all the things you need to prove to win your case, and then figure out what evidence you have to prove each of those elements. Too often I find there's one or two elements that sort of get short shrift, and those are the ones that make you lose because you didn't really address them, or maybe you didn't have anything to address them. But I think sometimes people fall back on my number 2 point, which is a little bit of I understand why people do it, but often we'll have somebody get up and testify for 30 or 45 minutes about the important work that this organization does, or why this building is so important. And I understand why people do it, but quite honestly, that doesn't do anything to help you prove that you meet the elements in the Papa G. You know, all these organizations that are seeking disaster relief are doing something that is public facing, providing public benefits. They're all important. And we get that. But the fact that yours is important too, isn't really, doesn't really, 45 minutes of testimony on that doesn't really help us understand how you're going to meet the elements to get a disaster relief recovery. We, as sympathetic as we might be, we are tied to the Papa G elements and how FEMA is allocating its scarce resources. So I often find if somebody's talking for 45 minutes about how important this work is, I'm wondering, okay, why are you doing this? You can't prove your case. Is that it? You're gonna focus on this and try to get my sympathy? Really, to me, it's better to really figure out how you prove your case. And that gets my third point, which Judge O'Rourke mentioned this, thinking really early on about what evidence you're going to need. And I know when there's a big disaster, it's really tough to do that. Other things were going on, but I remember one case that we had was about whether a roof needed to be replaced. And the only pictures we had in the record were after the roof had been ripped off to be reconstructed. There were no pictures of the roof as damaged. And that's that was a real problem, because there was no evidence that the roof was actually damaged to the point that it needed to be repaired or replaced. So that was a problem that nobody thought about taking pictures until after they'd already repaired everything. So that makes you consider your evidence super early. And I know that it's hard to do because you're trying to deal with a disaster, but it does affect your ability to prove your case sometimes. So it does require early on thinking. So those are the points I would make.
I think we can probably fill the remaining 5 minutes with our pet peeves if we try, but
I don't have any pet peeves.
Oh, no? Let me just make a plug for one, which is that anyone who's, as an expert, whether or not sort of formally designated as your expert witness or just happens to be an expert who talks to us, obviously is deserving of a lot of respect and deference to us. But just saying to the panel, I'm an expert, and in my opinion, this doesn't help us. And that can cover a lot of different topics, but we actually have experts come and say, in my opinion, this damage resulted from the disaster. And a panel thinks, well, help me out with that, and it's much as Judge Sheridan was saying, that really, as in the rest of it, you need to link that up to evidence in the record. Why do you think that? And so that's one other thing I would add is that we will oftentimes hear from experts and maybe need to hear from experts. But just remember, again, we're not a jury, and we're not simply prepared to just say that, well, that person seems credible. We do want to hear it tied into the evidence that's in front of us. Why do you have that opinion?
Sure. Hey, let me actually raise something else. And I don't know how you all feel about this, but I feel like lately we have been getting a lot of requests to allow for oral argument by the attorneys or the parties in lieu of having the live hearing. So that is, when we would normally have the hearing, the parties, instead of having witnesses testify, they basically give a presentation, an oral presentation, sort of summarizing their case, the evidence, putting everything together for us. I actually don't mind that. I think it can be helpful if done well. But I wonder how the rest of you all feel about that.
It's helped on occasion.
I learn more from reading than I do from getting it through my ears. I guess I would tend to rely more on the application and the FEMA's reply than I would to have somebody put it together for me orally at the end of the development process.
Yeah, I think
I mean, I would prefer if they have something new to say, or I'm not even sure briefs would need to be issued. I mean, we do have a tendency now to issue decisions without hearing briefs. Okay, so you need to be aware of the fact that your application and your response is pretty much it as far as making an argument is concerned. Because a lot of us don't even look to the transcript of the hearing in which the closing arguments are made. So, it just makes it more important that you put your best foot forward in the initial part of the arbitration.
Sure. Another thing I've noticed is that parties sometimes assume they sort of regurgitate the briefs, assuming, I think I think I can speak for all of us. We read the briefs pretty carefully before we get into an arbitration hearing. So we're pretty familiar with it. And often we have questions written. So I think you can usually assume that we actually have read the briefs pretty carefully, and try to work from there. Because I think you can start a little bit further in your presentation than you might if you're trying to teach us the basics about the case. I think sometimes you lose us. We sort of glaze over it a bit if you're starting at too basic a point. And then when we're getting to the part that we really need to listen to, maybe we've glazed over too much and we don't jump in mentally enough when we should. But that's one thing that I think you can assume that we're actually pretty familiar with the record, with at least the briefing and at least good parts of the record, and just can use your help to focus on where we need to go.
Great. Judges, this is Robert Nichols. I want to thank you for your time. It was very insightful. I clerked years ago as well. And the best lesson I learned from clerking was understanding how the sausage is made and how judges think and how the litigants present before them. So I guess my last question to you all is, my guess is that you guys could look at a typical case and identify the most effective elements of the case along the way that actually help you to do your job. And then there's a lot of other talk that doesn't really help you to do your job because it's either redundant or it is puffery or it's not really grounded in facts. And so the key word here, I think, is effectiveness. What is most effective at making a case before the board? And it sounds like the answer really is focusing on the evidence that supports all of the elements to meet the standards of the Papa G and 2 CFR. If you focus on meeting those elements with evidence, all of the packaging around it is a lot less important, it sounds like. Does that make sense?
Well, that's pretty much what I would say. Yeah, no, I totally agree with you. I do find, I mean, you can tell, you can sniff out when there's no evidence to support one of the elements, because parties tend, at least in my opinion, start to put a lot of puffery around around that element and they never really get to the nitty-gritty part of it. And you get a feeling that, when you I'm going to dig into it and figure out there's really nothing there to support that, but puffery. And that's a problem. And, you know, it may just be there is nothing to support it and you're doing the best you can, but
or you might be giving too much credit to the advocate. It may be that they think that the conclusory statements are effective, but they're just really not.
No, I think that's a good point. And the advocates really are usually the ones that are familiar with the rules and the regulations, but I think to the extent that the emergency managers in the field understand what the standards are, you know, one of the things that where I think the parties or the applicants get stymied is the sufficiency of the evidence. And the Papa G says it's got to be the who, what, when, where, and why. And that's what it says. And if you ask 5 people, whether they're lawyers or not, what that means, that's going to mean different things to different people. And a lot of applicants will say, well, you know, the FEMA rep in the field said we'd get reimbursed for that. We hear that a lot. And I understand the frustration, but FEMA is a large organization. They have a lot of different people doing a lot of different things. In the wake of a disaster, and they have a hierarchy as well, and they have procedures and regulations that have to be followed. So you have to be very careful to rely on a statement like that. So when you develop your evidence, it's got to be independent of statements from a field rep, for example. And, you know, I would just say, if the standard is who, what, when, where, and why, you know, you want to make sure you're on the real solid end of that. You know, you're not maxing the mins there or just skimming those.
That's great. Judges, you're welcome to stay on. Brock and Allison, I'd like to ask you to turn your cameras on. Just while they're doing that, I started my career at the Army Corps of Engineers almost 30 years ago. And for those of us older people online, you may recall this movement toward partnering that occurred back in the 90s, a way of ADR to try to avoid litigation. And we really bought into it. And, you know, our view is that if you actually end up in litigation or arbitration, you've already kind of lost. The whole key is to try to understand exactly what will be effective from the very beginning so that you can check every box along the way. And I think that Brock would agree that if that's done, you never need to appeal. You never need to go to arbitration, but it's a matter of understanding exactly what's required in the application for what will actually get paid, what you need to demonstrate, et cetera. Maybe Brock, can you take a moment to introduce yourself?
Yeah, my name is Brock Pearson, and I'm the Deputy Associate Chief Counsel for Disaster Litigation and Arbitration. And it's an extremely long title because that's what we love here at FEMA. But that basically means I'm in charge of overseeing our agency's disaster litigation and arbitration from CDCA.
Brock, would you say that where there are denials that end up in appeals, it is usually because there's not an adequate understanding of the rules themselves, so you don't have adequate documentation, trying for costs that really can't be recovered, et cetera? In other words, an applicant who wants to achieve a particular goal, but you have to check so many boxes to get there, and they don't necessarily know what those boxes are. Is that the case?
Yeah, there's a lot of boxes to check, and that's a true statement. But the CBCA was correct in saying that there are things that applicants need to meet to get the the assistance that they're eligible for. Documentation is obviously key to that. FEMA can't give money out to things it doesn't know exists. So we need to have ample documentation for the project that you'd like to do, but also it needs to be done in accordance with our regulations, the Stafford Act, and our policies, including the Papa G, which you heard today. All of which is available on FEMA.gov if you want to see what those are, and any applicant is free to use those resources, as well as discuss these over with their recipient, the state's counterpart, and the FEMA counterpart, to local GFO, to talk about, their project, how it may fit in within FEMA's eligibility, and trying to resolve it before it gets to the point of any sort of administrative appeal or arbitration process. That's obviously the goal that we want as an agency, because we're really here to give out as much eligible assistance as we can, but we are bound by the rules as well. We can only give out what is allowed by law and our authorities.
Yeah, that's the tough part. I think for organizations that get denied funds, especially if the funds have already been spent, they see trouble, right? We're in trouble if we don't get these monies, as opposed to what's the solution? What's the path to getting paid? I think that's tougher. Let me take a moment to introduce Allison McCleary. Allison is with Tetra Tech and is a lawyer and is on the ground in Hawaii right now related to the wildfires. Maybe, Allison, can you give a couple-minute background on your, I think, very interesting perspective on the FEMA application and payment process, the appeals process, and how you and organizations like Tetra Tech help organizations get paid without going to litigation when possible.
Absolutely. And thanks, Robert. So I'm Allison McCleary, Director of Disaster Recovery Programs for Tetra Tech. And in that capacity, really help to directly advise mostly state and local clients, with technical assistance as they navigate FEMA PA. I mean, really and truly, that's the crux of what we do. I echo so much of what both the judges and Brock and you guys have been saying as far as proper documentation. And really, that's where we add value in that process is we partner with state and local governments largely and help them develop a framework that not only that they can maintain that documentation, but it's retrievable, it's organized in a way that we can tie it to projects and to eligible scope and cost, and how they can properly document that. And so that is critical. I would say just document, but what that and provide a framework in which they can house that and retrieve that as needed, and really help guide their FEMA partners, help them recognize that the PDMGs and the TFLs and everyone who is in the field directly supporting them immediately post-event are really helping to guide them through the process as well. And so helping them understand that process from the very beginning is a large part of what we do, and why, as you mentioned, I'm here on the ground so quickly after a disaster, is oftentimes to make sure those who will be interacting with their government counterparts at the federal level, that they understand the process, they understand the nomenclature, they understand what's expected of them. And I just think that's critical, that they understand the path that they are starting down early on, and understand how to successfully navigate that.
Yeah. In your experience, Allison, how much do grant recipients have in place ahead of disasters the tools that they need to be effective for recovery from FEMA? Or are they normally putting these things together ad hoc?
I think we're seeing a trend towards better preparedness. I think all of our efforts over the last few years, this is my 20th year in this industry, and I think all of our efforts over the years trying to magnify the preparedness word, to magnify that need, it has worked. And so we're seeing more and more state and local governments put in place standby contracts that we know that they are 2 CFR 200 compliant and are check all of those compliance boxes, but contain scopes that would be helpful to them come what may. So whether that's from EOC staff augmentation all the way through grant closeout many years later, that they have scope elements there that they can call upon and draw from and get resources to help them. So we're seeing a trend towards that, both at the state and local government, that more of them are putting in place and having those standby contracts available to them come what may. And that's a great practice. And that's a way to get the assistance they need at really any stage in the disaster process. And that includes appeals and arbitrations. So while, like I said, it could be anything from just staff augmentation and the expertise in their EOC or in the field, as well as through trying to prevent appeals, to informally deal with any kind of dispute as to scope and cost or eligibility, and then all the way through the inevitable that may happen in certain circumstances of an appeal or arbitration, and being able to empower them with the knowledge of the process, the expectations, as many of the judges have laid out today, and just make sure that they're empowered with that knowledge and assist them through that process.
That's helpful. So really, you could almost look at this as a spectrum from the very beginning of a disaster, or even before the disaster, putting in place the tools to be ready to put together your claims when the problem rises, all the way up through making sure your claims are adequately evidenced and adequately argued, and then they get to FEMA. And Brock, when they get to FEMA, you and I talked about this a good amount. Obviously, FEMA's goal is to get money out the door, right? You take no pride in not giving money out. The whole point is to get money out, and a lot of money goes out the door without any problems. Where do you see the problems arise most often that turn into appeals?
And thank you for that, because it is our mission to help people, before, during, and after disasters. And I understand the topic of this discussion is about disputes, right? But it's about arbitrations and, when that didn't happen in a way that, applicants wanted. But in the vast majority of the cases, it does work out. I will say, like 2022, calendar year 2022, we obligated over 25,000 projects. There were 52 arbitrations that year, so not even 1%. Really. Just this year alone, we've had almost 16,000 obligations. That's a little over $17 billion has gone obligated to applicants, with just I think we're at 33 arbitrations this year. So again, not even 1% really at this point for the problems that exist. And for those matters, the best ways to avoid those types of situations to be, that 1% of applicants where something isn't quite going the way that you want is definitely through documentation. Maintain it, ensure it's detailed, and provide it to FEMA so that we can see what's happening, on the ground, see what's happening with your project, and make the proper eligibility decision for your issue. Make sure your costs are reasonable as well. Reasonable cost is always a big issue that we see, where an applicant pays for something but can't document why they paid that much for it. It's certainly an issue that comes up in CCA a lot, and it certainly comes up, in our applications as well. What else do we have? We also want to make sure that and meet all the deadlines that we have. We have a few, and they are all out there for the public to see in the regulations and in the PAPA G. Unfortunately, we are a large agency, so we have to stick to the deadlines that are out there. So know them, discuss them with the recipient, discuss them with your people representative, and follow them as much as possible. It's a great way to avoid problems down the line.
That's great. Sam, you were at the board, clerking at the board when this statutory authority went into place, and were there for writing the rules. Can you give us your sense of the role of arbitration here, and when it is a useful alternative to appeals within FEMA?
Great question. I think so. Both Judge Sheridan and Judge O'Rourke were talking about how, and Judge Chadwick, this is designed to be a fast, expedited procedure. And I think that's the overall, that's the theme that runs through all these regulations here. You know, an intent to have a process that's 120 days. And so I would suspect, I always see it as sort of a safety valve. So if you're in the appeal process, you've been there for more than 180 days, you have this alternative that you can go to that's an expedited procedure, a 120-day procedure. And we hear from clients again and again that the issue is not so much whether they're going to win or lose, but that they need a decision fast, because the cost of money is a real issue. And so I think that's perhaps the great element, the great aspect of the arbitration. The other thing I think that we have found to be useful and helpful for folks in the past is that a lot of the general principles are very clear, like you should document, and as much as possible, as soon as possible. But exactly what thresholds those are is very difficult to determine, especially because there's such a volume of guidance out there that is necessarily going to contradict from time to time. And so one of the great things about arbitration is you give this to a body that isn't living purely within FEMA's PAPG world. You give that body, you lay out all these different alternatives. And this body that is normally, it's designed and trained to resolve CDA disputes like a judge in any other case, is going to apply those same broader legal principles to this question that sometimes otherwise is just can be narrowly determined with inside appeals. And so there was a question in the chat earlier about like what percentage of cases actually overturn. It's a small percent, but it's sometimes very dramatic. So one of the first cases that came out that I love dearly is Cabo Rojo. And it's a situation where the board simply threw out at the rule at the time for determining whether an applicant was eligible for either a rural or urban classification. So these sort of things do happen. And I think they only happen in arbitration because they are looking at it from that different perspective. And perhaps the last point on this, and I'd love to get Brock and Allison's idea too, is I believe it was Judge Lester mentioned that it's very important, the more complex the case is, to maybe have this additional capacity to do arbitrations, whereas very simple issues maybe don't need this. And so to me, that is doubly true for arbitration. If it's a really important issue that must be determined, it's nice to have a separate body decide that. But I'd be interested in your opinions.
Allison?
Yeah. I was going to say that, Congress made this available to applicants to, make that decision on their own. This is, something that it's probably very individual to every applicant out there as to who, they want to have looking at it. It could be a number of reasons why they would choose it. Could be financial, could be, time, could be, a number of them. I would say our second appeals, we don't actually have any late ones. So once it gets to second appeals, it will be decided within the statutory timelines for that. There are some late first appeal decisions that are out there, obviously. I believe it's about a little under 100 of them total that we have right now. I believe we're over time. And that is actually a priority of the administrator this year, is to help clear out that backlog of late first appeal, so that applicants won't have to wait for decisions on any eligibility that they have. That's certainly a goal they have, and we're hoping the appeals folks here at FEMA can meet that goal. Obviously, again, we would love it if no arbitration ever happened, right? We would love it if appeals didn't happen. We would love applicants to get the money that they're eligible for, but unfortunately, as is the case with a lot of things in life, not everything can go the way some folks want it. We have to follow our regulations, we have to follow our authorities, and we're bound by them as stewards of the taxpayer dollar.
I think that, Brock, is one of the most important points here that in the government contracts world, we're intimately familiar with, but not everybody is. And that is, federal agencies aren't there to hurt you. And they're not there to deny you money. They're there to actually be helpful. But they have to live with the rules too. And if their interpretation of the rules is that your expense doesn't qualify, they need a judge to tell them if they're right or wrong. And that's really, I think, a nice outlet. It's a nice alternative forum, because if you get to that point of being at the end of the first appeal and FEMA and the applicant simply do not see eye to eye, at that point, the issue should be fairly clear. If they simply do not see eye to eye, and you really need a neutral third party to decide on these things, okay, it's there for that purpose. Allison, can you tell us a little bit about your experience with FEMA arbitrations?
Sure. I think it's a valuable resource for us. And having had experience under the prior iteration post Katrina, I started my career with the state of Louisiana, and having that option was so critical for a lot of those early decisions. We talk about often that disasters are unprecedented. Well, sometimes there's just going to be eligibility decisions based in those disasters, or what people have to do to respond to those disasters, that will also be unprecedented. So having that independent set of eyes, that independent set of ears, was really important. And we found that out through that process, and navigating subrecipients through that process in Louisiana. So we're really glad to see it in its current iteration and its current form. It's an important resource. Sometimes worry about access. We have subrecipients that, who represent all different levels of government and levels of sophistication and experience in the FEMA PA program. So I oftentimes, just with my background being mostly at the recipient level and in state government, would encourage state governments to really step into that role as recipient. I happen to work for states who took that role very seriously and were very proactive with the assistance that they provided to subrecipients. And I would encourage those in the call who may be representatives at that level to do the same. There is a role for recipients in the appeals process. There is a role for recipients here in the arbitration process, and even in the prevention of the utilization of this process. There's a role that recipients can play, and being good stewards of the program, working with their subrecipients, helping to ensure access not only to processes such as appeals and arbitrations, but also to information. And so we oftentimes would develop toolkits and, sources of information from the state themselves. FEMA has done a tremendous job in recent years of developing toolkits and resources and trainings on a variety of topics. But a lot of times that subrecipients will look to their state and their recipient for that type of assistance. And they're just a trusted resource for a lot of that information. And so I'd encourage anyone on the call to really step into that role as recipient if you are fulfilling that role, and look to what you can do to better assist subrecipients in accessing this as an option for them.
So I'd like to chime in as well and say that just because the CBCA is independent, I don't think makes the outcome necessarily that much more different for applicants. I don't have the exact numbers in front of me, but I know when the process first started, second appeals were granted at a higher rate than arbitration decisions were in applicants' favor. Currently, I believe they're about running neck and neck in terms of who gets more decisions in their favor versus FEMA. So it just because it is an independent body that's looking at it doesn't necessarily mean the outcome that could be affected by this is going to be any different than it would be.
You raise a really good point, Brock, because really the point of this webinar is not everybody should go arbitrate, right? The point of it is that this is an option that's there really at the end of the cycle. And the cycle starts with having good tools in place to capture claims and document them initially, and then potentially going through the application, potentially going through an appeal, not an appeal, through an audit, eventually going through that first round of appeal. And there are plenty of people, Tetra Tech, we help organizations set up the tools, go through audits, et cetera. But then if you get to that first hard decision point, or not the first hard, if you get to that hard decision point, we have not succeeded in being effective with the first appeal. Do we want to go in for a second appeal, or do we want to go to the board? That to me is the tough decision point. And maybe I'd ask Sam and Brock to talk about your views on what the factors should be in that decision as to whether to go to arbitration or to a second appeal at FEMA. Brock, you want to go first?
Yeah, again, like I said previously, I don't want to step into the role of an applicant and the decisions that they make. Those are very individual decisions based upon the project at issue and the determination that FEMA made that got them in the position that they're in. I would obviously prefer everyone just go back to FEMA and talk, with if you're going to do a second appeal, file a second appeal, have a conversation with headquarters and see if we can't get your decision overturned. But I think it is an individual decision, and I would hope that we don't even get to that point, even though obviously we certainly do.
Yeah, and before Sam answers, Brock, how much is FEMA open to having conversations, sit-down conversations about these things before an applicant has to decide whether to go in for a second appeal or go to arbitration?
Generally, that decision is made independent of FEMA. It is through the applicants.
No, I'm sorry. So
Yeah.
an applicant has a they've lost their first appeal, right? Is FEMA open to sit down conversations at that point to try to discuss, resolve, settle? Or is it really at that point, you can either file a second appeal or go to the board?
Yeah, so FEMA's first appeal determinations are final determinations unless they're appealed. So in FEMA's mind, it is a final decision unless you appeal it. We're not able to talk about it anymore at that point unless appeals actually do go through.
I gotcha. Okay. Sam?
I think there are two characteristics that answer this question. The first is by virtue of being an arbitration panel, it's not bound by a specific precedent. So if you lost your first appeal, the second appeals are online, you can search them. You look into these second appeals and you find, it seems like FEMA is consistently interpreting this a single way that's not helpful for us. Then you might want to think about going to arbitration instead to get a fresh look on this issue, because the facts you lay out before that panel are determined just by that panel. And obviously they're going to follow policy, et cetera. But it is that fresh look take to it. The other aspect, I think the second defining characteristic that's decisive here is the nature of the arbitrators themselves. Like Congress could have chosen any kind of body to arbitrate this, but they chose government contract judges. And government contract judges bring a certain perspective to things. You saw it a lot actually in Judge O'Rourke's answer, when she was talking about procedural adequacy, and when she's talking about expert classification. There's a whole process for classifying an expert in government contract law. So they see things as judges. And so I think if you've lost your first appeal, and one of the reasons may be that it seems to you at least there's a conflict with inside FEMA regulations, you need someone to look at this in a more holistic manner, or you need someone who's not going to be strictly tied to what you at least think is FEMA's perspective of this, then I think those are things that really push towards arbitration. And the third reason is the timeline. So if you're in a situation where you've been waiting a while, for whatever reason your appeal's delayed, or for whatever reason you need a resolution faster, then that I think is another indication that you should probably go arbitrate. And that's of course just my opinion, but that's how I see it.
Sam, you read my mind about the time frame, because we're talking about arbitration being such a great option as far as their expedited time frame. All of the judges mentioned that their process really moves quickly, and it does. And that's a value. There is a time value of money for these recipients, and a timely decision is often critical as they're just continuing to chart their path towards recovery. And so I've practiced and worked in several very, very busy regions, in regions 4 and 6, who do tend to get a large number of appeals, and arbitrations do come out of those regions more often than others. And the arbitration option, as far as after you file a first appeal, and if you still are awaiting a decision after 180 days, that arbitration is then an option for them. That can often be a valuable option based on that time value of money and them just needing a decision on some of these critical elements of their recovery. So I think that's a great opportunity for subrecipients to continue to just push those timeframes and push towards a more timely recovery.
And I would say in 180 days, it's important to ask why something has delayed that long. I would say in a lot of instances, it's a result of documentation. Those issues would probably come up in the CBCA as well. I don't work on appeals, so this is all from past knowledge of working on appeals, working at them late. But I haven't touched them in several years. But there's a lot of what we call RFIs that get issued by FEMA when we don't have enough information to make a decision yet, which can draw out the appeals timelines quite a bit. But those are necessary for FEMA to be able to make a decision that's in line with our regs, and would be necessary for the CBCA as well. So it's important to not just look at the timeline and why things are the way they are, but also look at what is the reason for why this project has languished this long out sometimes. And sometimes speeding it up and just jumping to the CBCA in the middle of it is not necessarily what may be in the best interest of the project itself.
Yeah, very good points, Brock. The last point I'll make is one of the government contract concepts that we bring to the table here is the idea of a pass-through claim. Often the grant recipients themselves really kind of just want to get out of the way, right? Between the contractors who need to get paid and FEMA themselves. And so this idea that the recipients don't necessarily need to be in the lead on this but rather the contractors can act as, if you will, a pass-through or use a pass-through agreement for that, can relieve some of that burden. I know we're out of time. Karen, I'd like to take a minute to thank all the judges. I see Judges Chadwick, Sheridan, and Lester are still online here. Allison and Brock, thank you so much. And Sam, thank you for putting this together. I think it's been very informative.
Thank you all.
Thank you, Sam.
Thank you so much, Robert. I appreciate that. Thank you very much to all of our subject matter experts today, Sam, Robert, Brock, Allison, the honorable justices for being with us today and lending your expertise and clarity to the very complex issues around PA grant appeals and arbitration. Thank you again for attending. Stay well, and we hope to see you again very soon. Have a productive rest of your day.